Hi, I'm Andrew Meinzer of Meinzer Law Firm PC. In this video, we'll continue to talk about how to sell a house or other real estate in a California probate decedent's estate court proceeding, or probate. This is the third video in a 7-part video series. In the prior video, we discussed the first 3 steps for selling probate real estate based on the default, with no authority under the Independent Administration of Estates Act, or IAEA. Here we'll discuss the last 5 steps of that process, which are: file with the court an appraisal of the real estate, accept a purchase offer on the required contract form, arrange for increase of the surety bond amount if applicable, obtain prior court approval of the sale, and then forward a certified copy of the court order approving the sale. And I'll discuss them. After being appointed in the beginning of the probate, one of the executors or administrator's initial responsibilities was to file with the court an inventory of all probate estate assets that also indicates their values. That includes probate estate real estate. For more information about the initial inventory, see our prior videos about probate decedent's estates. The real estate sale price needs to be for 90%, at least 90% of the value of the real estate as indicated on an inventory dated within 1 year of the court hearing for approval of the sale and indicating a value of the real estate as of a date within 1 year of that court hearing. So if the date of the initial inventory, which is the date it's signed, or the valuation date of the real estate on that inventory is more than 1 year prior to that court hearing for approval of the sale, then generally the executor or administrator must obtain a more current appraisal and file it with the court. The real estate salesperson must be sure to receive purchase offers on the correct contract form. It needs to indicate that the sale is contingent on court approval. If the executor or administrator had to file a surety bond with the court to be appointed, then the court will not confirm the real estate sale until the bond amount is adjusted. Generally, the surety bond amount needs to include the value of all probate assets other than real estate, plus the anticipated annual income of all probate estate assets, plus, in some counties, an additional amount to pay for the cost to recover against the bond in case doing that becomes necessary. After the sale, real estate, which does not need to be included in the bond calculation, is converted to cash, which does need to be included in the bond amount calculation. Accordingly, the original bond amount becomes insufficient because now you have more cash, and the total bond amount needs to increase, as will the annual bond premium amount. For more information about bonds, see our prior videos about that subject. The court likely will not enter the order approving the sale until that increased bond is filed with the court. Be prepared to pre-qualify overbidders during the second court hearing to confirm the real property sale. It's not unusual for strangers to be in the courtroom prepared to bid the sale to a higher price. If so, the judge will conduct an auction in the courtroom and the sale will go to the highest bidder. Finally, the last step is to forward to the escrow company a court-certified copy of the court order approving the sale. Escrow companies normally require that. At Meinzer Law Firm PC, we have over 20 years of experience helping clients achieve their goals in probate cases. Again, I'm Andrew Meinzer of Meinzer Law Firm PC. If you know that you need our help, or even if you just have a question, please contact us and let us take care of you.